Thank you. Good morning. It's the convening of the Massachusetts Gaming Commission, and we hold this meeting virtually, so we will do our roll call. To my fellow colleagues, good morning. Commissioner O'Brien.
Good morning. I am here.
Commissioner Hill, good morning.
Good morning. I'm here.
Commissioner Skinner, good morning.
Good morning.
And Commissioner Maynard, good morning.
Good morning.
All right. So today is September 19th. It's a Tuesday, starting right at 10 a.m. It is our public meeting number 479, and we are having a special meeting today on one topic, and it is a convening of a roundtable of number of stakeholders who have expressed an interest or have an interest in our regulation 205 CMR 257 that addresses data privacy. We have used this convention of a virtual roundtable to learn more from our stakeholders when questions arise. We work hard to become informed. We are at a stage in this regulation that's a little bit different. We have had a number of public comments about this regulation, but again, because there were outstanding questions, the commissioners all decided that we wanted to hear more. So with that, I'm going to turn to our legal team to help set the stage both substantively and procedurally with respect to the regulation. And then, as our agenda points out, we have some prompts. Before we get started on the discussion, I will have a round of introductions, and it is a large group, and we want to express our gratitude to all of you for making the time today to have this conversation and help us understand things better. But I think we'll start with our legal team, and I think Caitlin Monahan of our Gaming Commission will start off, and then we have folks from Anderson Krieger who will also help set the stage. Good morning, Caitlin.
Good morning. Yes, thank you, Madam Chair, and good morning to everyone on this call. I am going to quickly turn this over to Mina Macarius, who's a partner at Anderson and Krieger and has been our outside counsel working with us on this data privacy reg. Mina is going to walk through the structure of the reg just so that we're all on the same page for this conversation. And then, of course, we are here for any questions that crop up over the course of this discussion. So we're looking forward to hearing what everyone has to say today. Thanks, Mina.
Thank you, Caitlin, and good morning, everyone. I'll try to be brief because, as the chair said, we are all eager to learn from the group and hear about your perspectives on the regulation. So first, this is a matter of process, where we are with this regulation. This regulation was passed in the normal rather than emergency course. There was a, I believe, 60-day comment period, if I'm not mistaken, Caitlin, and both a presentation of the draft regs followed by a discussion of the comments received. There were many pages of comments received from both operators, other interested parties in the Attorney General's office as well. The regulation was developed initially based on a set of comments that came from the Attorney General's office on prior versions of other regulations. So this actually started way back in January with comments received from the AG's office on items in 138, 238, 247, 248, and predominantly the advertising reg. The commission made the decision early on in the advertising process that issues of data privacy and data protection, while important, didn't really fit in with the advertising regulations. They were separate. There was some overlap, of course, but they were separate, and tasked the legal team and staff to work on a draft regulation. So this is the product of that work, that input from both internal and external stakeholders and the comment period. And it is in force, however, subject to the requested waiver, and at the last commission meeting, a discussion that the roundtable would be useful to understand more particular feedback. I'm going to give a very brief overview of the regulation and sort of its overall structure without getting too far into the weeds. The regulation it has 6 sections. It starts with a definitions section. There's 2 key definitions here. really, there's three definitions total, so might as well cover them all. One is the data, what a data breach is, which is defined to be identical to what's in section 93H. So that's chapter 93H, excuse me. So data breach is defined exactly the same way as state law. Then there are two other definitions: confidential information and personally identifiable information. And the key distinction between the terms is that personally identifiable information is sort of traditional core privacy information, including under state law, that allows someone to identify a person. Confidential information goes beyond that and includes, among other things, sports information related to the sports wager account, the placement of wagers. Really, what the way I've been thinking about is what a patron does on a particular platform or at a sports book. It is not just the personally identifiable information, name, birth, etc. The substantive sections of the regulation then start into data use and retention, section 2, which includes a couple of broad statements about what data can and can't be used for. The can largely consists of anything that has to do with operating a sports book, or including, thanks to some helpful comments from operators through the process, the ability to respond to subpoenas, to anticipate and have alerts for red flags or problem behavior on a platform, fraudulent behavior, et cetera, to debug and identify errors, really a broad swath. The prohibited activities start in section 3, 257.023, and the key phrase here is that it reads, a sports wagering operator may not use a patron's personally identifiable information or confidential information or any information derived from it to promote or encourage specific wagers or promotional offers based on, and it has a set of criteria. And these are the sort of prohibitions based on behavior, on the due to dormancy, the use of responsible gaming cannot be used to then promote wagers. That's how that's phrased, et cetera. There's also within this section provisions regarding how retention of data should be carried out. We received comments sort of on both ends regarding the proposal to have an opt-in proposal, so something where someone has to allow the use of data. This is, in large part, we know this is something that European markets have followed, although we acknowledge there is, some of this may be new to some of you. So this is one of the things we're, I think, eager to hear about, as Madam Chair's prompts will show. 257.03, and I am flying through these, so of course, if there are questions as we go that are helpful for us to address, we can do that. Has to do with data sharing, where data can be shared with third parties. And effectively, at a very high level, a lot of this is intended to mirror 257.02 to say, we understand businesses require sharing data with vendors and others. When you do that, it's holding them to the same standards that you're going to hold for yourselves with what you do with your data, and including understanding what their policies and security policies are and internally. 257.04 relates to patron access. This is covers the methods of transparency for patrons to understand what is happening with their data. Importantly, we have, again, thanks to both helpful input from folks at the Attorney General's office and at the operators during the comment period, made some tweaks from the original draft comments that a lot of you probably have saw before the final, to make sure that there are ways for operators to say that when they cannot meet a patron request for security reasons or otherwise, or to not even have to say that you don't necessarily have to, for instance, dispose of data that a patron may say, I no longer want you to hold my data, because there may be reasons to hold the data for other legitimate purposes of the enterprise. 25705 requires a program, a data program, sort of to capture all of this and make sure it's happening. It's akin to a lot of the internal controls processes. That the regulations are only as good as what you're able to implement internally for your processes. And then finally, 25706 is intended to cover data breaches. An important note about this is there is some immediate notification to the commission required to allow coordination and investigations. However, there is no intent, and we tried to make this very clear, to supersede or create any conflict with other data breach notification protocols you might have under applicable state or federal laws. And that's today for current laws, as well as something we're keeping an eye on, of course, is to the extent the Commonwealth or the federal government develops other federal laws. Those will either supersede this, or the good news is this is done by regulation. We would certainly recommend revisiting all of this in that instance to make sure we're staying consistent with state law. So, Madam Chair, that's a very quick sprint through the regulation, but if there's questions, I'm happy to take them now, or otherwise I will be listening intently like everyone else.
Thank you, Nina. Thank you, Caitlin. Thank you to the entire legal team. Played such an instrumental role as we stand up this new industry here in Massachusetts. I know you've all been watching this team at hard work, so good time for us to express our appreciation. So at this point in time, I think it's important for us to do our introductions. I decided to go on a little bit off agenda so that we would move right into our conversation with our name tags on. So I think what I'll do is I'll start with the operator representatives. And again, we very much appreciate the interest and the willingness to appear today. Massachusetts does things in public, and we are always appreciative of the cooperation we receive from all of you. So I'll say the names and lean in, and if you want to say a couple of words about your role, we'd love that, so everybody gets to know each other a tad. Okay, Alexis Coco.
Hi, thank you. My name is Alexis Coco. I am the Associate General Counsel handling privacy and product at BetMGM. Nice to meet you, and thank you for having me.
Thank you. Jackie Crum. Good morning, Jackie.
Good morning, Madam Chair and Commissioners. I'm Jackie Crum. I'm the Senior Vice President and General Counsel for Onco Boston Harbor.
Great, thank you. Good morning, Corey Fox.
Good morning, Madam Chair and Commissioners. Corey Fox, Vice President for Product and New Market Compliance at FanDuel. I've been at FanDuel for 8 years, and I've been involved in every step of the way of launching sports wagering for FanDuel in Massachusetts. We thank you very much for taking the time to explore this issue more deeply this morning.
Thank you. Alex Ursa, good morning.
Good morning, Madam Chair and Commissioners. Thank you for having us. I'm Head of Gaming at Beta, where I oversee product engineering and operations.
Nice to see you. David Prestwood, good morning.
Good morning. My name is David Prestwood. I am Government Affairs Manager at DraftKings. I have with me a colleague who can fill in the gaps that I can't fill in. Dan, can you introduce yourself?
Yeah, sure. Good morning, everyone. Dan Kiesak, VP of Engineering at DraftKings, and I'm here to share any technical details that might be relevant to the conversation.
Excellent, thank you. And David, just so you know, your audio is a little off, but we can understand you. It's just a tad. I don't know if that can be corrected. Next, we have Leo Wan.
Hi, Leo Wan, VP Legal, Intellectual Property and Privacy at Penn Entertainment.
So, Leo, do you want to have your video off? Or are you having technical issues?
I'm having a little bit of an issue with my camera this morning.
Okay, I don't know if we have a trick for him, but I'll leave that to folks if you want to weigh on our team to weigh in as we do these introductions. Good morning, Leo.
Good morning.
And Dan Miller, it is nice to see you today. Good morning.
Thank you, Lady Chair and fellow commissioners. Good to see you too.
And you are?
I apologize. We do this so frequently. Daniel Miller, MGM Springfield Compliance Director.
Yes, thank you. Jennifer Roberts, good morning.
Good morning, Madam Chair, members of the Commission. Jennifer Roberts, Vice President and General Counsel of WinBit. I'm also joined by my colleague who will introduce herself, Sarah Partita. She's the Chief Technology and Privacy Counsel for Wynn Resorts.
Good morning.
There you are.
Hi, Sarah Partita, as Jennifer mentioned, with Wynn Resorts. I'm Chief Privacy and Technology Counsel.
Good morning, Sarah. Okay, and then we have Chris Willard.
Good morning, Madam Chair and Commissioners. I am also having some technical difficulty with my webcam, but I did put on a suit today, so I definitely want to be on camera. I am Chris Willard, VP and Chief Corporate Counsel for Marketing and Privacy.
Okay, and we're going to turn to those tips in just a second because I don't want a good suit wasted. And Chris Tarbell?
Yes, good morning. That's right. Good morning, Madam Chair and Commissioners. My name is Chris Tarbell. I am Associate General Counsel here at Fanatics, and I support Fanatics Betting and Gaming, the sportsbook, as well as the rest of the Fanatics enterprise.
Okay. Any tips for Leo and Chris, Grace or Dave or Mills, how they could maybe get their cameras going? Any thoughts?
Down in the left-hand corner of your screen where the mute and stop and start video button is, there's a little arrow in the video icon that would open your video settings. That would be the place to fix any issues if there were any, to select the appropriate camera. If there's any way to fix it, it would be in there. Otherwise, sometimes a good old-fashioned exit and rejoin tends to work.
Yeah, but I'm going to try the exit and rejoin.
We'll see you in a bit. Okay. Excellent. All right, then we're going to move on to our other guests. Those are all the representatives from our operators. And again, thank you, showing. We're very pleased to have the Attorney General's office represented. Good morning, Jared.
Good morning, Chair. Good morning, Commissioners. My name is Jared Reinheimer. I'm the Chief of the Data Privacy and Security Division, at the AG's office. I'm a lawyer. We do civil law enforcement work around data breaches and also just around privacy generally. Yeah, that's me. Thanks.
And thank you to you and your colleagues for your good contributions along the way, both with respect to the advertising regulation and in particular this one. And then we're turning to our technical experts who have served us so well as we went through standing up the sports wagering industry, the GLI folks. Good morning, Joe. It's been a while. Do I see him? Don't hear him.
Can you hear me now?
I can hear you now.
I am Vice President, Joseph Bottom, Vice President of Government and Regulatory Affairs for GLI. I oversee the regulatory advisory and relationship team. I have with me Mark Robertson. Do you want to introduce yourself, Mark?
Oh yeah, Mark Robertson, Senior Gaming Technical Advisor. Happy to be of assistance.
Good morning, Mark. Thank you, and thank you, Joe. These gentlemen are very much aware of the technical requirements, and there are questions around implementation. So we really appreciate your sharing your expertise today. And then finally, we have a responsible gaming expert, and that's Dr. Michael Wohl, who has been advising us along the way and works on research projects with us. Is Dr. Wohl there, please?
Good morning, Madam Chair and Commissioners. Michael Wall, I'm professor of psychology. I'm joining you from Carleton University in Ottawa, Canada. I've been doing research on the antecedents and consequences of gambling with a specific focus on responsible gambling for the past 25 years. Thank you for allowing me to join you today.
Thank you. And this is why virtual works really well. You didn't have to jump on a plane to get to us, as well as many of you. So thank you. So commissioners, this is going to be a conversation, but again, we should really feel comfortable following up at any point in time with a question that you might have. If it just makes sense to ask that right then and lean in. And I'm just going to ask also if the four of you can help me navigate the conversation, because I'm looking at a lot of squares and they'll be leaning in, and folks might decide to use the icons. That's okay too. You don't have to. There you are, Leo. That worked. And now we just got to find out if it worked for Chris.
It did. I am here.
There you are. And that
rebooting always works.
Yeah.
On and off.
And we see the suit. So it feels good. All right, great. So it's definitely more of a navigation now. So we're going to turn to, or definitely more of a conversation and conference room. So now I'm going to navigate by starting with a prompt. And I want to thank Commissioner Maynard. He worked with me and the certain members of the team as we thought about these prompts, and we hope that they will help with the conversation. So I'm going to start really at the high level. Prompt is, please detail the specific requirements of the Commission's regulation not currently imposed in other jurisdictions that present challenges. So those of you who work in other jurisdictions, why don't you help us understand those outliers? Who wants to go first?
So,
Here we go, David.
Madam Chair, again, I'm David Prestwood. I'm here in my role as Government Affairs Manager at DraftKings. As we were looking at these prompts last Friday, and after some pre-meeting consultation with Director Band and staff, several of the operators gathered together and thought that it would probably be helpful if we could do a brief presentation on some of these issues in the form of a deck, just to kind of set what the current landscape is, talk a little bit about our compliance processes, and then what some of the timelines and implementation challenges here would be, because these are such highly technical issues. And we'd like to start by responding to this prompt, if that's okay. I can share my screen. My colleagues Alexis Coco from BetMGM and Corey Fox from FanDuel can take part in this presentation, and then you can feel free to interrupt with questions. But I think that framing it in a kind of, here's where we are, here's where we're going, here's an overview of the challenges would probably be helpful.
Okay, let's see how it goes.
All right, let's see if I can share my screen first of all. All right.
Of course, just so you know, I won't be able to see faces now. So those of you who want to weigh in, I guess, David, it sounds like you're going to lead, but if other folks want to chime in, I really do encourage other voices. So thank you.
Yeah, and absolutely. I'm not trying to make this a one person or one operator show. So,
yeah.
So these are the 5 areas, as I mentioned, we kind of want to talk about. I'll respond to your first prompt with a first slide, which is what the existing landscape is. So as you may know, the California Consumer Privacy Act was the first comprehensive data privacy law in the US. It was passed in 2018 and became effective in 2020. And that spawned many additional comprehensive state laws. And CCPA and those laws have a number of key things in common. They permit the processing of personally identifiable information based on consumers consenting to a privacy policy. They afford consumers the right to opt out of having their data sold or shared to third parties for non-required purposes. And what that means is when the third party has some independent commercial purpose for that data. They also afford consumers rights to access or delete their data, or generally to correct errors in that data. They also require businesses to employ reasonable security measures without generally setting a particular standard. And they obligate businesses to then conduct privacy assessments of their data processing practices. And finally, these apply to all industries, only exempting, say, businesses under a certain size or those for which data is already covered by another regime. So, for example, HIPAA for certain medical data would supersede those laws. And so to talk about your prompt a little bit, let's talk about some of the unique requirements of 257. The first is it flips the way consent operates, potentially requiring patrons to opt into each individual use of data that is not required to operate the wagering platform or comply with the law. During the original meeting in which these were adopted, Commissioner Skinner asked a question about what other jurisdictions allow for opt-out as opposed to opt-in. And the basic answer is that every jurisdiction in the US that has dealt with these issues has an opt-out regime. So this is something that is entirely new for domestic US operators. The regulations impose blanket prohibitions on using certain personal information for promotional and analytics purposes, including things like period of dormancy, which you see, across business lines, across all businesses. Critically, it doesn't allow critical data sharing with third-party vendors, even when consent is obtained by an operator. So at present, anything that is not required to operate the platform or comply with the law may require this opt-in consent specific to each business purpose under the regs. What the regs don't appear to do is permit sharing of that data with third-party service providers, even when we get consent to process information for those purposes, if it is not a required purpose or required to comply with the law. And the result of that is it makes it practically infeasible to conduct a lot of legitimate business practices like marketing and analytics and consumer outreach, because vendors are needed to conduct all of those services. This requires consumers to opt into myriad individual uses of data one by one. And it also provides that all of those are revocable. And no other privacy law does this with respect to so many legitimate internal business uses. So the potential result is every individual customer could have its own menu of acceptable uses for their data, and that would be extraordinarily difficult to implement. 257 also requires operators to encrypt or, thanks to amendment, hash and protect all PII, including by multi-factor authentication. No existing law does this, and really for good reason, is that many types of PII just do not present the kind of heightened risk to the rights and freedoms of individuals, even if they were improperly accessed or disclosed. I'm talking about things like IP address or device ID or mobile advertising ID. There's nothing anybody could really do with that information, even if they accessed it. And so this is why state breach notification laws, including the 93H in Massachusetts, focus only on sensitive PII, like government-issued identifiers or payment card or financial information like account numbers. But beyond that, encryption in many cases is impossible. For example, how do you encrypt something like a public username? And this is why other privacy regimes have exceptions for things like publicly available information, which isn't present here. So that's a unique challenge. As you know, this applies to a single industry and requires that industry go it alone. When CCPA was passed, it applied to all industries. And one of the benefits of that was that there was incentive for third parties to develop tools that were designed to streamline compliance and assist businesses in managing data in a compliant manner. Because this applies to 8 to 10 companies, no such tools exist. And so as we build processes, we're kind of on our own in the process, which can lengthen the compliance timeline. And finally, there's no clear timeline for compliance here. I think one of the reasons that CCPA was relatively manageable for companies, and that's probably an exaggeration, it was actually very difficult to get off the ground. But one reason is that it was relatively so, is that it built in a multi-year approach with clear timelines for implementation. And so before we move on from this and get into questions, I mean, this seems pretty daunting, and I want to highlight where I think to date there's been a disconnect between operators and the commission. It's not that we disagree on the importance of data privacy, or certainly of RG. It just has felt like we aren't speaking the same language. When we talk about these things and we talk about how 257 is unique or unprecedented. I think the commission has taken that to mean that the strength of consumer protections are unprecedented. And what we're intending to communicate is that that's not the case. 257 is different regimes that doesn't necessarily make it stronger. So what our concerns are that it is in many cases more invasive and it's challenging to implement, in part because it has all of these unique components. It's not an extension of any existing legal framework in the US. And so we want to talk about those implementation challenges today. At the same time, I think a lot of these things could be managed if the commission was open to revisiting parts of the regulations. And I'm not talking about striking the whole section. I mean, I think the commission has been clear that you don't want to go that route. But revisions here really are much needed. And operators are broadly in agreement that the process to date has not, I think, represented the seriousness of some of these concerns and how challenging this actually is practically to implement. I mean, I think after watching the meeting where 257 was adopted, there was a consensus among operators that our written comments were not really deeply evaluated. I think a lot of them were highly technical and drafted by teams that included experts on data privacy regimes, including many of the folks on this call. And there was not a significant amount of discussion on a lot of those comments. I think several comments were disregarded entirely and they weren't even mentioned in the meeting. And so without that detailed analysis of these concerns, I think that showed up in that meeting. Commissioners said, well, there's only really one operator that's concerned about this. And that wasn't true. I mean, there were comments from many operators, or acknowledged that the commission wasn't quite sure how long compliance would take, despite comments that, operators kind of uniformly said this is probably a multi-year process. And then the regulations were adopted despite that uncertain landscape. And so in addition to talking about the implementation challenges, we want to highlight that we think there are ways to accomplish your goals that are cleaner and clearer and easier to implement. For the concerns that are specifically data privacy, if that's the concern, that's great. I mean, we are very good at protecting consumer data, and we would love to share that expertise in really focusing on how to protect consumer data. I think a lot of the concern represented here is responsible gaming, and that's also great. We've worked with the commission on adopting all kinds of regulations on advertising and marketing and RP. And so there may be ways to focus these on responsible gaming that still allows for these regular business functions. I think we've got plenty of time to make some changes to the regulations, tweaks here and there to provide clarity and support for operators while meeting the commission's goals. And again, I'm not talking about starting over, but talking about making clarifications. I think, the turnout here indicates that we have a lot of questions we want answered, but we're really ready to work with you. And we hope that we can work together to make these kind of make sense for everyone. I don't know if there are questions about this, and other operators can jump in, but I'd like to turn it over to Alexis from BetMGM to talk about how product change actually works as we look to implement.
I'm going to ask this question, David.
Please.
Do you intend to show another slide, or is this your only slide?
We have a few more slides just to outline. Alexis will present them before.
Okay.
Yes.
So commissioners, why don't we pause here? Could you just take this PowerPoint down for a second, please?
Sure. And I'm happy to share this after the meeting as well.
Yeah, we'll go back if you're going to go to page 2. So David has given a presentation that shows the outliers, and then I think that we're going to move next to BetMGM. I'd like to hear from others in terms of what's been presented, and then I do want to hear from the other stakeholders as to what has been presented thus far. And that includes, I suspect, our legal team. There was some. We do pride ourselves on having rigorous discussions, and perhaps, as David pointed out, there were times when we should have asked more questions. So maybe, this is a good time for us to pause and think about that as well. Commissioners, and particular questions you have, and then turn to our participants for any input. Okay, yes, go right ahead, Alex.
Thank you for the opportunity. While I haven't contributed to the presentation, I totally agree with it. I had the opportunity to work with, like, for example, with Corey and launching so many jurisdictions at my time at FanDuel, and there were, I would say, a couple of layers that we've seen through the process. And I watched all the sessions on YouTube, so I kind of enjoyed it. So as it was said, I think a lot of the comments were not presented, and I think missed the substance. Sometimes it was like some of the comments were like, well, some operators express concerns about this without giving the details on the concern, but we still think it should remain as is, as presented in the regulation. So it was, I would say, maybe it's unfair for me to say, but a bit impartial from not like providing the full picture of the operator. And the second thing is, I think the speed as we're moving with the new regulations. Again, I think GLI is here and can attest, because I think they are overseeing regulations and testing in, I would say, almost all jurisdictions except a couple. The moment you go from discussing to actually promulgating and being in effect, it takes like some between months and years, depending on the complexity. In this situation, we've been put into a process where regulations were presented and adopted through the emergency process. And even if, let's say, there were some comments accepted, it was really hard to comply in such a short time. I think there are other jurisdictions where changes to the regulations happen, and it's perfectly normal as things evolve, but takes, I would say, months until they are put into effect. And I think that's one of the biggest challenge we face and was presented here.
Okay. I just want to turn to our Attorney Reinheimer. Do you want to weigh in at this point?
Sure, thank you. I think I am certain that there are going to be technical challenges in implementing some parts of this regulation, and I think that's totally understandable. I think with respect to there are a few points that were brought up that I want to just present some perspective on. So first is the consent mechanism. I think opt-in consent is something that is being used broadly in Europe currently under the GDPR. And it's my understanding that a lot of those consent mechanisms were intended to be adopted in this particular regulation. The principle, I think, behind that is sort of a pretty, what I would say is common sense one. If you want to use someone's information, you ask them first. And that seems like a reasonable approach. I'm sure that there are technical challenges to some of those particular types of consent, but I don't know if changing the consent mechanism is the appropriate way to address that issue. I think the other thing that I think is worth distinguishing here is there's a concept of data privacy versus data security. So data security, very important. It is, the methods that companies take to prevent themselves essentially from suffering from security breaches, right? So Chapter 93H in Massachusetts, and there's plenty of other analogs in other states, require notifications in the instance of a security breach, right? And the primary harm that those statutes were intended to protect against are things like identity theft, people losing money, people having difficulty obtaining access to credit because somebody else may have opened a credit account in their name. And so those laws are really directed at financial account information, social security numbers, and that sort of personal information. So 93H, which is a law that our office enforces regularly, along with data security regulations that are in place from the Office of Consumer Affairs, those are largely directed towards those financial type harms. Data privacy, on the other hand, is sort of a different focus, I think. Data privacy is really about respecting the consumer's right to control how their information is used. And I see this regulation tackling both of those issues, but I noticed that there is a lot in here that is very important with respect to data privacy. And we think it is important, especially in the context of this industry, which is new. It's and it's very data dependent. And so with respect to like the timeline for getting things done, I think you know, a lot of the operators have pointed out that there are laws already in place. And so I don't think it will require as much of a head start as say that when the CCPA was implemented, because that has already been put in place. And so there are systems designed to deal with that. But also I mentioned the GDPR before, and I think at least some of the operators already operate in Europe and so are familiar with that. And I think we'll be able to adjust based on that. Of course, I don't see within the operator systems, I don't know exactly all the technical challenges that are going on, but I really would be interested in hearing more about what the specific challenges are here. I think the one that jumped out at me in particular was David had mentioned that they can't share with third-party service providers, even with consent of the patron. And I was just curious what specific sharing that encompassed, because it seemed to me that the permission to use information to operate the sports betting platform would cover things that are needed there. So those are my initial thoughts, but I'm sure I'll have more in a little bit. Thanks.
Okay, and we'll be delving into implementation challenges in more detail. I'm going to turn to Alex for a response and then go back to David, and unless somebody else chimes in, I just am looking at people leaning in. Alex. Oh, you're on mute.
GDPR is brought up a lot, and I'm not sure how many folks on this call had the opportunity to work on it. I actually had the opportunity to work. Before joining FanDuel, I worked at Betfair for Flutter many years, and I was actually part of the team that implemented the GDPR changes across multiple brands. For context, there were 25 months between promulgation and going into effect for GDPR. And it went, like, the amount of work that went there was thousands of people across the entire organization, because you have to do first of all, an audit of all data and how it's managed, data governance, and then how you implement that. So it's been like about 12 months of just understanding and planning before actually real work has been done. And again, some things already done for the US platforms, but I'm not sure how many operators are using the European platforms in the US. So I think that's a big nuance that we need to look at. It's easy to compare with GDPR, but again, there were 25 months from promulgation to implementation in Europe. That was one thing that I wanted to point out.
Alex, I'm just going to piggyback to say GDPR was also a document that was worked on over the course of several years. I think it was like a 4-year development process as opposed to several months that we've had here. So there was a lot of notice even ahead of that 25-month implementation timeline.
Okay, anybody else want to weigh in at this point? Okay, Mina.
Madam Chair, if it's appropriate, I don't want to go too far back and forth, but a couple of things were said during the presentation. I just want to make sure are clear so that when you do talk about implementation, we're not, you know, and if we're not talking about requirements that aren't there in the reg itself. And I'll leave aside the comment about the comments. I think, well, actually I won't. Let me address that real quick. There are about 30 pages of comments that were included in the commission's packet. We did go through them. We did go through each one of them. I will note that the very first comment this is for several operators. I hate to pick on it, but it was the first one on here, requested that this reg be struck altogether. Several operators had asked for that. There were some more detailed comments. We did make some changes based on some of those detailed comments, but I respectfully disagree with the implication that the team at the commission didn't go through them. That being said, I think it's important that the operators identify which particular language they are dealing with, because we want to understand what is hard, but we also want to make sure that folks are not creating challenges for themselves that the commission's not asking them to create in these regs. For instance, on the data sharing, in very broad terms, says that a sports wagering operator shall not share patrons' confidential information or personal identifying information with a third party except as necessary to operate a sports wagering area, sports wagering facility, or platform. That goes beyond what's legally required. That is what you need to do to run your business. And that was, and thanks to helpful comments from WinBet, we broadened it to include some additional legal requirements so that there would not be a question if an entity found itself in litigation or subject to a subpoena that they needed that. It's far from saying you cannot share with third parties. And so I would just ask that we try to focus on the language that's there, not the language that we're worried could be there. And if the language isn't clear enough, I think it'd be helpful for the legal team's perspective to hear what edits would be suggested for that.
Yeah, I hope we get a little latitude today, Mina, to, you know, I think everybody's going to focus on the language that's there, but this is I think that what you're pointing to is a fair question, and I think it was one I was going to ask you. What third parties are we talking about, right? Are they outside of the realm of sports wagering? I think that's, and I think then that begs a question that we're going to get to, which is why is that important in the industry? But Mina, go right ahead, finish that.
Sorry, and if I could just make one other point so I don't have to keep interjecting. The other question, and I guess just one thing I didn't bring up in the, maybe as clearly as I wanted to in the introduction, and I just want to make sure we're understanding in terms of the question of the timeline piece, because we understand the timeline. You know, we're asking for something to be done. As the commission's asking for something to be done. The commission is also asking for policies to be put in place to make sure things aren't done. And I wasn't sure if that was clear in the presentation, that some of these things are not a matter of setting up new measures, and Attorney Reinheimer kind of got at this. They are also asking what is in place to make sure data breaches are prevented and data is not misused or used in ways that aren't allowed. And I think that's just a different category.
Thank you. Okay, I'll turn to Alexis. Good morning again.
Good morning. Thank you again. I just wanted to build a little bit on what's been said and clarify. We are here today to have this conversation to understand what the commission believes to be necessary. So one of the suggestions that we had made was something that was reasonably necessary. Many of us are lawyers, we're used to parsing regulations and may get a little, oh, is it necessary to do a promotion? Is it necessary to do marketing? I was happy to hear that Mina said, well, what's necessary to run your business? Because I think a lot of things are necessary to run our business. But it's very difficult when the language is necessary. You know, for food, it's necessary that you have vitamins and some nutrients. Is it necessary to have coffee? I agree it's necessary to have coffee every morning. If I don't have coffee, it's not going to be a great day. But is it really necessary for a human to function? It's trying to understand what you want so that we can provide guidance to our product teams so that we can meet the regulations. And because we haven't had a ton of back and forth on this with you, that's why we all ask for this roundtable and why we all appreciate the time that you're giving to us here.
Okay, very helpful. I think I'll turn back to David, who needs to speak in order to pop up on my screen. There you are.
Hi.
And I don't know, I think you might have planned on going to Alexis next, if I remember correctly, but you had a second slide.
Yeah,
there.
I want to be clear when I talk about what happened at the initial meeting. It's not a dig at outside counsel or MGC staff or anyone. You know, I'm not saying that the regulations weren't reviewed. I think in watching the meeting, it seemed like in the meeting, the commission wasn't maybe presented with the analysis that those folks went through. And that I know is a function of Massachusetts and that you are required to do open meetings. And I think that because of that, a process in which maybe it took several meetings to kind of get into more granular detail is something that the operators would have preferred. You know, I'm not saying people didn't do their jobs. I'm just saying I think it's hard when you're talking about such highly technical issues to present all of that information that the commission may need. And so that's one of the things that we want to do now and do going forward. But the reality is that because the regulations are already in effect, there's a waiver process to do that.
David, and I appreciate your clarification. I did hear you say it that way, that it was more on the commission's engagement and asking of questions versus the team did its work. So thank you.
Well, and all that we as operators are able to see is what happens in the public meeting, and I watch every single one. So that I definitely, that's what we can take. I want to talk about briefly when I talk about, for example, the third party issue. In 257.02, it has this language about you can only use confidential information as necessary to operate or to comply with law. And then 257.02.2 says if an operator wants to go outside of that, then they have to get opt-in consent. And that first one is mirrored in 257.03 about data sharing. It says you cannot share except for as necessary to operate or to apply with applicable law. But there's no mirror of that second point that says if you choose to use it for something else and someone has opted in, then you're allowed to share. And so that's what we're talking about where, I think that's a simple clarification. My assumption is what the commission intends is for if an individual opts in to an operator using their data in a different way, that operator can then share with third parties specifically for the purpose of using the data in that particular way. It's just not present in the regulations. And so those are the kind of clarifications that we're talking about. Because right now there's just a hard stop on even information that patrons have opted into allowing use of. And again, I don't think that's an intentional thing, but it's something that based on the way our businesses work, where we do use third-party vendors for a lot of these things that patrons would opt into, and they keep that data tight, and we follow the requirements here, that they would have to follow the same data security concerns. It's just on the privacy front, it would, in order to follow up on the opted in use that the patron has chosen, we would have to share that data with third parties. And under the regulations as written, we couldn't do that. So that's an example of one of these kind of technical things that we're talking about where, again, I don't think it's intentional, but we would need to change to actually operate. I hope that makes sense.
Commissioners?
Chair, I have a question.
Thank you.
David, when you say opted into, don't you mean haven't opted out of? Because there is no opt-in in any other jurisdiction. I think we've confirmed that, or you've confirmed that earlier.
Yeah, I mean under these regulations specifically, where if we set up a process in which a patron needs to opt in for a particular service, whatever that may be, in order to actually use that service, we may have to share their data with a third-party provider. So one of our vendors, for example. But the regulations here don't give us the opportunity to do that because those things aren't necessary to operate a sportsbook or aren't necessary to comply with the law. Even if they've opted in, we would need language in the data sharing that says, hey, if they've opted into this, you can affect the thing that the patron has asked for by using your third-party vendors.
So I think my next question has been alluded to a couple of times. What vendors would you be sharing this data with? What vendors that aren't necessary to your business operation would you be sharing this data with?
I mean,
if you could give examples, right? I'm looking for examples.
Yeah.
Some practicality. But thank you, Commissioner Skinner.
Can I also add to that question, which is, you can put them in buckets, right? Which is, what are ones you would see easily fitting into this regulation, and one of the ones you're thinking wouldn't, to Commissioner Skinner's point?
Well, I'm happy to take thoughts from other operators on this. I don't want to, monopolize this, but let me say, for example, let's say hypothetically a patron opts into receiving physical mail from a sportsbook. Unless the regulations would not permit us to share that personally identifiable information, for example, name and address, with a third-party vendor that prints address labels. Under the regulations, if we wanted to do it, we would have to print everything in-house.
I see Alexis, she wants to add in, maybe?
Yeah, there are also, I think, rewards programs that exist where patrons would like to use the rewards points that they may have gotten through us to with other partners to cash in for hotel rooms or to cash in for sort of other physical rewards, where we would typically provide them with, they would know that they're going to a Marriott and using their rewards for a Marriott, but then we would have to communicate with Marriott that they have these rewards. So what we typically try to do is provide them with that information before they connect accounts or before we send the information to the third party. But without, I would say it's really necessary to our business model, but is it necessary to operating a sports wagering platform? This is the type of thing that I want to make sure we are doing correctly. And as long as we get clear and conspicuous consent, which I think you've built in to the regulation, into the first part of the regulation, if that would be mirrored in the sharing part of the regulation, that clear consent would be permitted for those types of third parties, where they do have a little more control over the data that we share. I think that's what we are potentially hoping for as a group, is both the making sure that necessary means includes printing vendors and software providers that we use to run our business, sort of on a general, that you would think, oh, of course you have a printing provider. We're not printing postcards and handwriting them in-house, right? We're not doing all of those things. We use a third party for printing. We can share in those ways as long as there's a contract that protects the sharing. But then there's also some sharing that we would make sure is specifically opted in when it's not a necessary this type of sharing. So that's how I see the distinctions that maybe we would want to make sure we cover, and that we're not running afoul of what your hopes are for this regulation.
Thank you, Alexis. Commissioner Skinner, do you want a few more examples? Or Commissioner Maynard, another bucket?
I'm good, Chair. That was very helpful. Thank you.
Yeah, thank you. Commissioner Maynard?
I guess I would just ask the legal team that it was contemplated, right, that if a patron opted into direct mail, what's the example Mr. Presley gave, that they could actually share that with a third-party vendor. That was a necessary operation to then get the mail out, correct?
Yes, if I may, Madam Chair, to Commissioner Maynard's question, yes, I think that was contemplated. I can see a potential tweak to make that clearer. So it was helpful to get that that kind of particular example. I think what is a policy question for the Commission, we don't need to weigh in on it right now, is the issue. The reason that there wasn't a mirrored language is that consent for sharing with third parties in the sense of other advertising partners, which is common in some industries, we know, right? That if you share with an airline, they will sell to a credit card company or somebody else. That is a different policy question than necessary to get the job done that was opted into, which I think is already contemplated, but certainly could be clarified.
Those would be the other examples that might be a further stretch, right? And so I think that would be helpful. The couple that showed up, I think tweaking is easy, but if we really do need to press further, I think I need some more examples that might be harder for you to share with us, Corey.
One other example I just wanted to point out was much of our marketing apparatus, which includes our customer relations management, in other words, the emails and messages that we use to communicate promotions to our customers, is driven from third-party software as a service vendors. So we are, in a sense, sharing information with those vendors. I think I hear Mina's comments to mean, so long as the underlying activities are permissible, that it is necessary to operate the business and we would be able to do that sharing, but that is the kind of vendor that was particularly alarming for us, that we would potentially not be able to share information with.
Alexis?
I mean, I agree with my colleagues here. I think I might be presenting the next slide, so I'm not sure if it's me, but I certainly want to make sure everyone has the opportunity.
This is it's going to shed light on it. This is, I think I hear Mina saying it's a policy discussion, but I think all of us might benefit from, you know, that spectrum, because and the impact as we move along a different third-party vendor that, you know, we're not hearing about. So this is the opportunity. But we can go to that slide, and commissioners, unless you want to help me weigh in on that particular issue right now. Commissioner
Madam Chair, before we move on, could I just ask Mina to remind me the timeline on this reg? When was it proposed? When was the open comment period? Where do we stand now with the waiver?
And I'll ask Caitlin to back me up in case I have the dates wrong.
Sure.
But we,
Yep.
I believe, proposed, the draft was discussed in June, I want to say. It was voted on, there was a public comment period thereafter through July. The comments were received towards the second half of July. I'm sorry, I don't have exact dates. It might have been middle of July. And then there was, the public meeting was on the 8th. When they were approved, with contemplation of this roundtable being part of that. And then there was a waiver voted in, they wouldn't have taken effect until end of August, early September. There was a waiver right before when that would have happened that gave about a 60-day window, which is what we're in now.
I can add a couple.
Right?
Well, apologies, Chair. I was just going to add a couple of dates. So yeah, the commission first saw this reg on June 1st, as Mina said. And then there was basically a 2-month comment period before it came back for a second review and vote on August 8th. So.
And then it was effective September 1.
And then it was in effect September 1, yes, with a waiver.
With a waiver. Okay.
And the waiver now extends to?
I believe November 17th.
Commissioner Bryan, is that helpful?
Yep. Yeah, thank you.
Okay, and do you have anything you want to ask about the third-party vendor question now? Are you all set?
No, I mean, it to be honest, strikes me that it's not, the sky is falling so much as clarity that needs to be sought in terms of the language. I thought it was more in line with what Mina said, which is if it was necessary to, you know, to run the business. If what they're looking for is further clarity and protection in the wording of the statute to make sure they're not running afoul of it, I think that's something that can obviously happen offline, more comments, you know, with the team in terms of making sure that that's finessed so that everyone's on the same page about what an opt-in allows the operator to do.
Yeah, I want to make sure that we understand from today's discussion from the operators what you view as so core to your business that we might not understand. If so, you know, so far the examples I'm hearing are very understandable as probably what we imagined. But I'm wondering if there's some example that's out there that you really want to be able to work with. And you haven't given it to us. It's a little bit more of a stretch. I mean, is it, you know, for credit, or is it something that raises the issue around data sharing that is pushing the envelope on a lot of discussions that are going around United States and the globe. So this is just an opportunity for that clarity as well. Okay, Commissioner Maynard.
Yeah, so since the commission's cognitive ability has come up on what we understood and didn't understand, I want to be clear. I'll just make a statement and then it can be responded to. I am glad that Mina clarified that we can get a little more language in there to talk about mailings, for example. And I did think that that was a permissible activity to share that information. But let me give another example. I didn't think a car manufacturer, I thought if an operator was going to sell data to a car manufacturer, right, that patron should know that and have to agree to that before it was sold, right? I'll just give an example. Or a watch maker or a clothing company or what have you, right? Airline, as Mina said earlier. I think that the patrons should know that. And I was very cognitive of that when I took my votes and was reading the regulation. So I'll throw that out there as an example of two extremes. I thought that the company that mails the mailer should be able to do their job. But I thought that, if Lexus wanted a hold of this information, the consumer should know that Lexus wanted this information.
I think some laws talk about reasonably anticipated uses. So that would cover, that's different than I think that may be the issue, is what's reasonably anticipated for a sports wagering platform or operation to run. People understand that they're going to get direct mail. They understand, certain usage. You would understand certain usage, Commissioner Maynard, versus, we're not generally data brokers. We're not selling our data to Lexus so that they can sell you cars. We really want to operate our platforms to the most efficient way. So I think we're essentially aligned on this. It's just making sure that the law reflects, or the regulation reflects, all of these things that we're discussing, which is really helpful for me.
Good. I think David and then Alex.
Yeah, I just want to second that. I agree that that's right. When I was talking about one of the things that the CCPA does, for example, where it allows consumers to opt out, it's opting out of data that is sold or shared to third parties for non-required purposes, specifically if that third party has their own independent commercial purpose for the data. So, for example, if one of us said, we're going to sell your information to Lexus, that's the kind of thing that's contemplated by these opt-out regimes, where it says, they have their own independent purpose. That's not performing a function of DraftKings or FanDuel. That's Lexus wants to send you a mailer to sell you a car. And so that's a little different than the language that's here, where it's talking about not selling data, but sharing data for operating the actual platform.
Okay, Alex, thank you.
Yeah, thank you again. And thanks, Mina, for the clarification. I think that helps, I would say, a lot. I think I have a few examples in mind that we could maybe just discuss and will help us maybe set a broader understanding or where we are. So there's, for example, a lot of the operators here will share specific relevant information with third-party providers that provide them responsible gaming services to understand behavior. We just assume then we don't need an opt-in for that, because that is actually allowing us to operate the business. That's an assumption I made after the clarification you presented. Is that assumption correct or wrong?
Commissioners, I think we would all agree, right? That's
great.
Part.
And then another example, maybe on the other side, from an advertising perspective, we have our marketing colleagues who are building up audiences, and while they're not sharing the data, not selling the data, they could share the data with platforms like Meta or Snapchat or TikTok, basically to build audiences to advertise to other potential consumers. Basically, does that include operating your sportsbook business, because you just advertise to potential consumers based on your existing audiences without actually selling the data?
So now I think we're getting into a realm where, for me, that would require a broader discussion. I mean, because I'm going to start expressing opinions that I think are probably better left for the five of us having written wording and written examples in some of this, because to me, you're crossing into a sphere of not necessary for the business potentially. So I think that's a very different question than executing mandated RG functions on an app.
I totally agree that, but I appreciate your feedback, but I wanted to kind of give a few considerations so you can think about it. So there's like the two extremes, maybe that's why I call them like the RG angle of it, and then I would say the marketing angle, and like that's where I think a lot of everyone is looking for clarity, because if it's not more clear, it's easy for us to basically be in a breach of compliance, maybe without actually wanted to do that. So definitely that's not something anyone is looking.
Commissioner O'Brien, if you'll allow me, because that actually was really helpful for me, because that really does show kind of the two ends of the spectrum. And if we are going to have our policy discussion, I do believe it would be reserved for the five of us, right, outside of this round table. I'd love to have a follow-up question. If Alex's example that he just gave is one that's really on top of mind, is this where does it lie in terms of an impediment for you to be successful in running your business? I mean, I think I need to understand that better.
So I have a follow-up to that follow-up too when you're done.
No, that doesn't mean, Commissioner O'Brien, please don't read into my position.
No, not at all. It made me think of something
right.
that would springboard off of that. So
okay, great, thank you. And I know this can be uncomfortable because we're in public, and I also am very mindful of the fact that there could be business implications. So if I'm asking a question you're not comfortable asking, that's okay too. We'll just move on. Answering, I mean.
I can talk about my broad general experience because we're in a public forum. I don't want to talk specifically about BetMGM. I was outside counsel to a number of companies and worked at a company in-house. I think our marketing teams, every marketing team I've ever talked to has talked about targeted advertising as being necessary to run a business. I think other industries use targeted advertising, and that's really what we're talking about here. Other industries use targeted advertising, and in order to be efficient, I think it would be unlikely that, I think it's likely that all of our marketing teams or our product teams would say that type of activity is necessary to run a business, or those types of uses or those types of sharing, unlike sending a list of all your customers to Lexus to sell them cars. But I think there's probably a space for opt-ins and opt-outs there. It's just, should it be a blanket prohibition? I think that would be a very difficult way. It would be very difficult for us to run our businesses effectively without that type of marketing opportunities.
If there's no immediate response, I'd love to turn to Dr. Wall, because I think there's RG implications here. We spend a lot of time thinking about our advertising and the benefit of targeted advertising versus that push that just goes general. So Dr. Wall, and then also I'll turn back to the AG's office. So and we are going to get into implementation issues and timing. So, but this is very helpful. Thank you, Dr. Wall.
Thank you, Madam Chair. And I do have a lot to say on the matter, but I want to make sure that the operators felt they had sufficient voice. And so thank you for making the time for me, because I have a different angle on this issue that I think deserves attention, one that directly focuses on patron health and the issues with data amalgamation or aggregation. The aggregating patron data from sports wagering accounts such that confidential information, so I'm seeing this as individual level gambling behavior, where that kind of data cannot be analyzed, can have both advantages and disadvantages when it comes to patron protection. And I think that it's essential that we weigh the pros and cons to understand why it may be detrimental for patron health in the long run. I'll start off with the advantages. First and foremost, there's privacy protection. So amalgamating data can help protect the privacy of individual patrons. It prevents the creation of detailed player profiles, which can potentially be misused or breached. But there's an array of unintended negative consequences that can arise from the demands to aggregate data. And if you'll give me a few minutes, I'm going to kind of detail some of my thoughts on the matter, and if I can remember what point I'm on, I'll say them in points. Number one is that it prevents effective responsible gambling monitoring. So responsible gambling programs rely on the ability to monitor individual gambling behavior to detect early signs of problem gambling. Aggregating data can make it challenging to identify at-risk players and provide them with appropriate interventions. Number two is that it prevents customized interventions. So individual level data allows for personalized prevention and intervention initiatives, such as Play My Way or risk identification programs. Without these data, gambling programs might have limited impact. Point number three is the loss of insights. So aggregating data can lead to a loss of valuable insights into gambling patterns, which could help develop more effective harm reduction strategies and programming like GameSense. I would be remiss if I didn't mention research and problem gambling research. Researchers studying the prevention of problematic gambling and the impacts of problematic gambling rely on access to detailed individual level data to enhance our understanding of disordered gambling. Aggregating data could hinder scientific progress in this area. And I will say that Massachusetts right now is seen as the crown jewel for gambling research. I'll be mentioning later on or soon Section 97. Researchers around the world see what's happening at access to data from land-based casinos due to Section 97 as a model for other jurisdictions. In fact, I have detailed sketches of a paper that I'd love to read on what I'm calling the Massachusetts model. And the current privacy legislation that I'm reading will not allow the Massachusetts model, what I'm calling the Massachusetts model, to be extended online to sports wagering. To put a dark line under the matter, when considering the concept of consumer protections, it's essential to distinguish between protecting personal information and protecting the well-being of the individual. Although aggregating data can enhance personal privacy, it may come at the cost of compromising the protection of individuals from the potential harms associated with sports wagering in specific and gambling more generally. I have a couple more points, if you'll allow me. The absence of player level data from online venues and sports wagering can create a significant blind spot for regulatory agencies, for MGC, in terms of responsible gambling programs. Section 97 of the Expanded Gambling Act provides a wealth of important information for player protection from land-based casinos. However, without a similar section for sports wagering and the provision of access to player level data, MGC may struggle to create and test the efficacy of online responsible gambling programming and compare gambling-related harms and protections stemming from online gaming compared to land-based gaming. So in conclusion, although privacy considerations are important, I think we need to be balancing them also with responsible gambling and responsible gambling initiatives, which can be complex. And the absence of player-level data from sports wagering can hinder the effectiveness of responsible gambling efforts and limit the ability to make meaningful comparisons between online and land-based gaming in terms of player protection. So I'll stop there, and thank you for the time to speak.
And thank you, Dr. Wall. Commissioners, we've not heard from Dr. Wall before, so this is an opportunity to follow up with him. I guess I'd love to know specifically what is troubling you most. Is it the opt-in? Is there, the specifics really matter at this stage. So commissioners, I asked that question, but I want to turn to yours first. Commissioner Bryant.
No, I had the same question, which is the same that I would ask of the licensees, which is, what's the particular language? I mean, there's also the reality of the statutes are different. I mean, we have to acknowledge that. That's just 23K and 23N are different. But what is the particular language that you feel is either lacking or troublesome in what's currently been enacted?
Yeah. So when I read this, what really popped out to me is the word aggregated data, and what is meant by aggregated data. Aggregation could just simply mean the collation of data, but my reading of this means that you will not have access to player level data. And that is really important to have for responsible gambling initiatives, initiatives like Play My Way, that when you aggregate data, you're collapsing across all data points. And when we know that the vast majority of players do play positively, you're going to eliminate the variance. You're going to eliminate the ability to detect who is perhaps playing more intensely and look at that level of analysis of what is contributing to this high intensity play. You won't be able to examine that level. You won't be able to look at that when data is aggregated.
Okay, so pause right now on, I've got Jared and Mina who want to weigh in. I don't know who raised their hand first, but I will go to Jared first. Mina.
Yeah, please do. I think Mina and I might be mentioning the same thing, but I think, Dr. Wool, the concern the only time aggregate appears in the regulation from my observation is 257.025, where it says a sports wagering operator shall collect and aggregate patrons' confidential information. And I totally understand your concerns. I think they're valid. I think you're right that a lot more can be told about someone when the information can be linked together to a specific person. And I think a lot of the software that's out there right now that identifies problematic gaming behavior in particular relies on the fact that it can be tracked back to a specific person. And so I just wanted to jump in to say, I think, totally understand all of those concerns. It seems to me as though the problem is just the and aggregate and that particular regulation, but I don't want to speak for you, so I don't know if you had a response to that.
You're right. This is where it's that 0.5. I have highlighted the word aggregate, and what does that mean? Will that preclude the ability to look at individual level play? We need to be able to look at how track an individual over time and see how their play changes and what they're playing. What games are they playing? Are they engaging in in-play sports betting? How frequently? And how does that relate to other behaviors? That's necessary when you're looking at trying to implement limit setting. You'll need individual level data to be able to suggest suggest to a player that they may need to set a limit. And the word aggregate here does concern me.
So that's an important piece. Dr. Wall, on my question, and forgive me, I might just be missing something fundamentally. Does it the idea that we would be requiring opt out? No.
Opt-in. Yeah. So that's the secondary concern because
it's an RG issue. Okay, thank you.
Right, because my guess is that you'll have a low level of opt-in. And so then any data that you get is going to be highly biased.
Yeah. Or we won't get the data for people who need it.
Correct. My guess is that, and most players who play problematically understand that they're playing problematically, and they won't want to provide their data. And that's the most important data to have available. So my preference would be to have an opt-out as opposed to an opt-in.
Very, very helpful insight, Dr. Wall. And Jared.
Yeah, sorry. I just wanted to jump in again to say, I think, the way that the regulation is currently drafted, I would view the requirements of, 257.02 talks about consent and asking for consent in certain circumstances. And then a later portion allows information to be used for responsible gambling purposes. And I don't view consent as required for that provision. But I am not the gaming commission. So Mina or anyone else, please feel free to mention how you view that.
Yeah, thank you. That's sorry for jumping in, but that's exactly where I was going. Is can MGC carve out research and RG that individual level data can be collected and used for research and RG purposes, and eliminate the word aggregate from point 5.
That address your opt-in, opt-out concern?
If it's still opt-in, so if you can carve out a section for research and RG and apply section 97 to sports wagering, then perhaps we don't even need to discuss opt-in, opt-out, because that's a separate point, that individual level data can be used for research and RG purposes. See section 97.
Commissioners, I'm having a little practical problem with that, because if you haven't opted in, your data wouldn't be available for the responsible gaming purpose. So walk me through that, Doctor. Sorry. Thanks.
Yeah, I mean, what I'm saying is that I would like to see that the language around opt-in, if opt-in is for operating purposes, sure, but for RG and research purposes, that the individual data can be used. And so the exception for point 5 would be that section 97 applies to sports wagering.
Mina?
Madam Chair, this may help just at least conceptually clarify how the commission could think about Dr. Wall's suggestion. Keep in mind, we keep talking about opt-in or opt-out, but the opt-in isn't about the data existing or in the first place. It's sort of by necessity operators have to have data that includes at the individual level, right? Just to be able to do the basics of confirming who you are and what you're betting on and what your account is and what your account's linked to, all of those things. All of this regulation is about what you do with the data. So I think Dr. Wall's suggestion, it's another sort of reason why these roundtables are very useful, is to make sure that everyone's reading things the right way. I certainly think the intent was to allow, was never to, just as Assistant Attorney General Reinheimer said, was never to disallow using this for
responsible gaming.
For responsible gaming. All the commissioners nodded when that was asked earlier. So the carve out, to the extent that's a clarifier, that could easily be done. On the purpose of the aggregating, same thing. The word aggregating here was, again, you know, we were thinking of a different issue. I'd be curious if with your indulgence for Dr. Wall's reaction to this, it was to aggregate behaviors in order to develop new techniques and new methods to detect problem gaming. But again, it's not in lieu of being able to get an individual who needs help, the help they need. So maybe the word aggregate is just in an unfortunate place, and that's what we could address that. But that's they're sort of different between opt-in for use versus the data will be there. It's how you use it.
Okay.
And I think we all thought it was necessary to business anyway, so got it.
Exactly.
Okay.
Thank you. I'm not a lawyer, so I'm reading this as a lay person. But if I would ask two things: either aggregate be explained, or that it be removed, and whether there's a way to refer to Section 97 here, that Section 97 applies to sports wagering.
Okay, Mina, and I think we'll move on.
I'd like to defer just thinking about that. As you know, we're always very careful when we take something from the Gaming Act and apply it in sports wagering to make sure that's an appropriate thing to do based on the legislator's intent. But it's the point taken from Dr. Wall's comments.
Thank you for your time. I appreciate it.
Okay, I'm going to go back to David. You had a second. I know we're looking at the clock too, but I also think we can, if everybody can take a breath, we might be able to go a little bit past noon, but I'm also happy to have a hard noon stop. So let's just do a time check. Folks, can we go a little bit longer than noon? Commissioners? Okay, everybody sort of nodding. All right. Okay. Back to David.
Yes, I wanted to turn this over to Alexis to talk a little bit about resources and project management, how we actually conduct product change, and then just to lay out what it actually looks like to comply with a regulation like this. Because I think that, you know, from those initial conversations about how long does this actually take, this is kind of a necessary background to provide color on what we actually do to comply.
Thank you, David. Do you want to share the slides again?
Absolutely.
As he's putting the slides up, I also want to recognize that we're in a public forum. And I hope the commission will understand that I'm speaking generally and broadly on behalf of all of the operators and not solely based on my experience at BetMGM. The operators are all aligned on these points. And as the process continues, each of us may be able to offer more specifics in a private setting without putting a lot of our system information online, which could create both cybersecurity issues and also some of that is trade secrets. So forgive me for being a little bit broad here as we move forward. I wanted to address your questions about resources and timelines because as this isn't a privacy on or privacy off button. If it was, I think we'd all be on happy to comply very quickly, but there are a lot of systems involved. We have product roadmaps where we have a number of cybersecurity upgrades. We have regulatory requirements in both in Massachusetts that we're working on and with other regulators. We are always trying to improve customer journeys And then occasionally we have incident response, troubleshooting, if there are bugs, they need to be fixed. So we have technical resources assigned in a long-term position to make sure that all of these things are within specific timelines. I think we talked about this was really only presented in June, and then there were changes. I haven't been able to put it on our product roadmap because we needed these clarifications. So that's why I'm, again, so grateful to have this time spent with you so that I can go back to my team and get specifics about how long it will take to implement X or implement Y. But we have product changes always ongoing. They're planned far in advance. Any deviations from our current plan require removing resources and then could leave customers vulnerable because we do need our information security personnel to be working on, the cybersecurity upgrades that we've already got planned in different types of projects. As we're clarified, we'll be able to say this may take 3 months, this may take 6 months. But I did want to say we don't have just a bunch of developers that are waiting to follow my instructions. As much as I would love to have that, we need to work with large teams of resources that may already be dedicated to other things. I did also want to say, and I think we've talked about this a little bit, this is not a blanket request for this data privacy regulation to go away. A lot of us are already meeting these requirements. We all, I think, either are or have the ability to turn on most DSAR, data subject access requests. For Massachusetts, I know BetMGM did that over the summer. So Massachusetts residents can submit opt-out requests, deletion requests, although there's sort of limited deletion, right, for all the reasons we need to keep it, right to correct, and rights of access. So that's been available to our patrons since this summer. You have some things in the regulations that require provisions in contracts with vendors. We've been using data protection agreements or DPAs or data privacy addendums on our template contracts that include a lot of the themes, but maybe not the exact language that you've requested. So we are already protecting all of our patrons. They are not just those in the states that already have these laws. We use them for blanket for all of our patrons. We also already offer advertising opt-out, and we don't market based on RG designations. I think that's really important, that we're not trying to use this in order to continue to market people based on them getting off of an RG distinction. We do need clarity, and we've talked about this a little bit, from MGC so that we can provide the guidance to our teams as to what does need to be built, what is necessary, what specific opt-ins are you looking for before we can operate. So I think we will have more clarity after this meeting and maybe after another meeting or after you've been able to sort of discuss where your distinctions lie for what is opt-in versus what out for what is impermissible sharing. And as we get these clarifications, we can put it into a project roadmap and then assign resources. But this isn't just an on or off button that I have the ability to put in. I've talked about building to my teams about building the registration journey and putting in different options. How many opt-ins do we need? What opt-ins are required? What opt-ins should we do? It can be very complicated and is not just necessarily an out-of-the-box easy change. David, could you go to the next slide, please? And this is an aggregation, we'll say, of all of the implementation challenges that the operators set forth in our exception requests. They're not specific to any operator. There may be more depending on the discussions that we had. I don't want to go into it because I know time is we're sort of going up on time. The one that I can easily talk about because I'm a lawyer is
Alexis, I think it's okay for you to take some time on this because we do want to understand this, and we also want GLI to weigh in on details. So, commissioners, are you looking forward to hearing a little bit more of the details, or Alexis should feel comfortable going through as many as she wishes?
Yes.
Thanks, Lakeisha. Commissioner Skinner, thank you.
Yeah.
Thank you. Okay, so Want to relax on time. Thanks.
Thank you. So I can speak to certainly some of these. The one that I was going to give an example because I'm a lawyer is sort of changing our contracts. If language is needed in all of our DPAs, that might require going to many different vendors, presenting them with an amendment, and then getting both our legal resources involved and their legal resources involved. Typically, when these laws have been passed, there's been an implementation period of maybe 18 to 24 months. So when a law is passed, what I do is I go to our template contract and make sure that if the regulation or the law requires specific language, that it's in our template contract so that 2 years from now, when the law goes into effect, we don't have to renegotiate every contract or contact every vendor. The themes are already covered, but the language that you've added may not exist in every single contract. And as you can imagine, every single contract may be a little bit different. We might end up engaging with third-party software developers or vendors or support teams to expand technical capabilities. When the CCPA was passed, and I think David went into this a little bit, there were vendors coming out of the woodwork saying, this is what we can do. This is our technical capabilities, because there was a market for for this. California is the 4th or 5th biggest economy in the world. So everyone operating in California, there's a lot of opportunity. When you're looking at 8 or 10 vendors in Massachusetts, we may not have the third-party tools that we would be able to typically rely on in order to get some of this done. Some of our systems or our products may not have the ability to segregate data in the way that we would need to implement this. Now, I don't have specifics, again, because we're in a public forum, but also because I was waiting, I think all of us were waiting for the instruction that we're getting today, or that we're starting to get today, as to how to clarify these things and how to classify potentially, necessary sharing that maybe doesn't require any opt-ins at all, with non-necessary that requires opt-ins versus impermissible. All of the data flows that we have, we need to reassess. We've assessed them obviously for CCPA compliance and things like that. I hope everyone has done, at least overall data maps, but looking at it under a new lens, under a new classification, requires input from lots of areas of the business. We've had this engaging discussion about where marketing is, what's necessary. I think if I asked 5 people at different operators or in the industry what's necessary, I may get 5 different answers. So trying to classify lots of different information flows or information data points, it just requires a lot more clarification and then decision making, and often outside counsel guidance, so that we're covered, so that we understand what you want and that we're compliant. Because the goal obviously is compliance everywhere. Building registration flows. We're constantly upgrading our registration flow to make it friendlier to the patron and also more efficient. I know we've got full registration flows that are approved by probably this commission, but also in other jurisdictions. So we may need to rebuild the flow completely, or an operator may need to rebuild the flow completely for Massachusetts with different options or different requirements. And I think making sure that does not interfere with other products that are going on and other analyses that are being done. It's going to be a lot of technical discussions with teams that aren't going to be fully dedicated to this, because, as I said, they're working on cybersecurity improvements, they're working on other product improvements, they're working to make sure that we're meeting your regulatory requirements and then regulatory requirements in other states where we operate. Not all of these pieces were mine. Oh, one of the things that I think is we've talked about opt-in and opt-out, letting people opt out to individual uses of their data. I don't think there's a tool out there that lets us do that right now. I use OneTrust. It's public. If you go to our privacy policy, you can click on the link and it'll take you to OneTrust, and I have an opt-out option for opting people out of all marketing. I'm honestly not sure how I would be able to opt people out, give them the option to opt out of individual uses. I'm trying to figure it out on the fly, and I think kind of you will be helpful. But that would also maybe require us to list vendors that we would otherwise keep confidential because they're part of our systems or they're part of our architecture that we wouldn't be sort of making public. So trying to figure all of these things out is just a process. And it's not that we don't want to comply. It's just that it is going to take a while to figure out exactly how to do it in the most efficient way that does provide Massachusetts patrons with the types of protections that you're looking for. So that's, I think, my slide, and trying to go into the right amount of clarification while also, keeping in mind it's a public forum, if that's all right.
Thank you, Alexis. If we could take down the slide so we can see each other again. I want to ask the operators, did you want to add any further clarification around those implementation challenges before I turn to GLI and ask about their thoughts? And then commissioners, if you want to weigh in with questions or comments.
I just wanted to add one piece. I think Alexis was framing it in a very generous way when discussing, sort of the individual vendor by vendor opt-out, saying it would take a while to figure out how to comply. But honestly, from my vantage point, the notion of each user being able to design their own individualized privacy regime for themselves, I don't know that that's at all possible. I think the only way we would be able to comply would be able to implement a much broader opt-out than the player was asking for. I don't think we would be able to do it on a vendor by vendor or information piece by information piece basis. So, I don't know what the language intended. Maybe there's a different interpretation, but when we read it, we had some serious concerns that was impossible.
Commissioners, before we turn to Joe and Mark, any questions for Alexis or Corey? And I think while we're talking about the implementation challenges, we've heard also some discussion around timeline. So, impossible doesn't fit on any timeline. So that's really helpful feedback, Corey. But otherwise, I'm hearing also timeline. Joe, what do you think?
Before you go to GLI,
yes.
Madam Chair, my question in general is, we've heard that the opt-in is being widely used in Europe. So I'm curious as to, I know some of the licensees operate internationally, some do not. So I understand what you said in terms of the difficulty vendor by vendor, information by information, as opposed to maybe categories of types of opting in or out. But can anyone speak to the experiences with the opting in Europe?
I see, Chris, you have your hand up. Thank you.
Well, actually, I just wanted to point out that, and I'm only speaking on behalf of Caesars here, but Caesars is primarily a U.S. operator, does not have any EU operations. And so developing a new opt-in mechanism would be the equivalent of having to comply with a brand new CCPA or GDPR. And so I do want to distinguish between, as we discussed before, there are a number of new privacy rights in this regulation that we can comply with, that we are already offering to Massachusetts residents. But the opt-in mechanism, given that it's brand new for the US and our systems are designed for the US with the expectation that sort of CCPA requirements would be kind of the outer band there, to have to redesign things would be challenging for all the reasons that Alexis discussed. Another challenge I wanted to point out is just the fact that Massachusetts will have its own unique version of opt-in rights. There will be a number of edge cases, things that we're going to have to figure out in terms of, we have a national loyalty program. We have operations in different states that have different rules. People have accounts in different states. People may sign up for a loyalty program in Las Vegas when they visit a property, and then later at a later time sign up for the Massachusetts a gaming service, but perhaps not opt into certain uses, and we need to figure out, well, what does that now mean for their participation in the Caesars Rewards program? So I think there just are a number of things that we need to kind of think through and understand what the rules are, and then it's going to be the hard work of developing the technical changes to make sure that all of these requirements are implemented.
So that, Commissioner O'Brien, that Caesar's perspective, is there anyone you're hoping to hear from, someone who has the European experience? I don't know. Don't mean to put anyone on the spot.
I would just submit from my perspective, we are a subsidiary of a European operator. I don't know the answer to Commissioner O'Brien's question directly, but I'm certainly happy to reach out to my colleagues in Ireland and England and get some more clarity on how they implement those provisions. I would just say, though, that our US account and wallet and data systems are built for the US. We do leverage certain information from Europe, but not those systems. So we'll get more information, but we're not ready to implement it just because they do there.
Right. No, I wouldn't think you'd be able to just, update and go running, but I'd be curious, if you can provide an update in terms of how it functions for your UK and Ireland operations. That I would like that.
Absolutely.
Commissioner O'Brien, did I not go back to you on another question? My apologies.
You basically did. You just didn't come back to me. It's you cycled into hearing from Professor Wall, because that was my follow-up question to where you had gone. You just went there on your own, so I didn't speak up.
Okay, my apologies. Thank you.
No problem.
I meant to circle back. Okay. All right. So I guess now it makes some sense, to really drill down on the implementation challenges, and we'll turn to GLI. Joe, are you prepared?
Yes, I'm here.
Thank you.
Everything presented so far seems reasonable, very reasonable. And while Alex did mention that we have been contracted to consult with Mass Gaming, our awareness of this regulation came at the same pace as everybody else. Some of the implementation challenges for this regulation, especially considering a comprehensive consent management system, certainly isn't anything that I would expect the industry to have ready. To manage those consents, it's not just a simple add a check a box UI change. There's a lot of re-architecture of the data and how it's tracked accurately to manage the consent and withdrawals to make sure they comply with this particular regulation. So I think that's one of the main concerns, and how they the rest of the United States has no such demands, plus how their player account management, their PAM systems are mostly universal from different US market to different US market. Mark, would you agree?
Yeah, segregating between the different markets on the consent would be a technical challenge.
I would expect a 2 months is no time to do anything like that. I can speak to that from firsthand experience.
So meaning the 2 months, because we have that November 17th date of compliance. That's what you're thinking, that I don't want to put words in your mouth. You said.
Yeah, it's a massive demand technically.
Okay, massive. Commissioner Maynard, and then I'll turn to somebody else. I think it was Alexis.
Thank you, Madam Chair. How long would this take in this form, and understanding that it sounds like everyone has acknowledged that there could be some small changes coming? How long would it take to implement this? I mean, I'm just asking purely technical. How long would it take?
I think in the operator perspective, we've all been talking about a year, maybe two, to meet all of the requirements. We haven't had the specific conversations with our technical team because we're trying to figure out what would be considered necessary, what would be considered opt-in. So I've had conversations with them, but they can't tell me it'll take 6 months or it'll take 9 months or it'll take a year because we don't have the specifics yet. But I think Commissioner Maynard, when we've discussed it as a group of operators, we've really said to fully comply would be, a year or two. But we would hope that I presented a little bit. We're already meeting some. We intend to meet others. Some of them may be easy fixes, and some of them may be product builds with third parties involved or legal or InfoSec approvals. So it would be, I think, a rolling product implementation, but I think GLI, Joe said it's a massive demand, a massive technical demand, and I'm certainly not going to contradict that. So I intend to go back to my product teams and sort of talk to them a little bit more based on this conversation. But then I think we also need to see where the commission ends up on the clarifications so that we can see what we can do versus what we can't do. And I want to also circle back to Corey's point that some things at the end of the day may not be technically feasible, but without the clarification, I don't want to sit here and say we can't do it versus we can do it. We really want this to be an iterative process so that we meet the themes, the privacy themes that you've presented and the cybersecurity themes that you've presented. I think we all care about privacy and cybersecurity. It's just a matter of how we get it done in a technically feasible way with the right resources.
I just wanted to add on to Alexis's point again, that I know that 2 years does seem like a long time, but if you look at other privacy regimes from CCPA to GDPR to in fact Massachusetts' own data security regulations that went into effect in 2007, I'm told, 2 to 3 years is actually not entirely uncommon for implementation of these types of data privacy regimes. So it is a long time, but these are really hard, and it's re-architecting a bunch of how our backend systems work.
That's fair, and I actually appreciate Alexis pointing out that some of this could be done quicker than other pieces, and that's something that I would definitely want to see. I'm gonna throw a provocative question out there that I don't expect there to be an answer to, but I want to prove the way that I'm thinking about. I really want to nail down how long technically would it take to implement this. Well, what if I were to take a vote to suspend all the temporary licenses, how long would it take to get this implemented? And again, I don't expect an answer to that, but my point being, I'm really trying to find out what could the resource and manpower be put behind this to get this done. That's what I'm trying to figure out and trying to understand.
And I just can't give you a specific answer without talking to my legal teams. I'm a privacy attorney, so if you want to talk about specifics of privacy laws, I'm happy to do it, but I'm not an expert on every technical piece of our product. So I don't for those teams and put them in a position where.
I'm going to turn to David because I think he's responding to Commissioner Maynard's question. Then I'll get to Jared, and I know we also have Director Band who's probably going to weigh in on GLI's role. But if you want, Bruce, I don't want to put you on the spot. So David, thank you.
Yeah, I think there are a couple of things. The first is, we're just a couple of weeks into this, these initial waiver requests, and one of the reasons we asked for these initial waiver requests were for scoping purposes. And so, our teams are doing that. We're all working on that and trying to figure out what the technical demands are. And so these clarifications are part of that. I think, secondly, it's not as simple as even if we had unlimited resources of just hiring a bunch of developers to work on this specifically. So, there's no way to even give you what a lower bound of that would be, because that would require, interviewing, hiring, training on the way our specific products work, in addition to all of that background scoping work. And I think that's why you see that even when other states have adopted privacy laws over the last few years, that were all modeled on the existing CCPA framework, the average is like 21 to 22 months before implementation. And that's with all of the tools and with companies already complying in California. So this is, because it is a totally different animal, I don't think any of us can at this point give you a reasonable estimate. And all of our systems are, honestly, they're built differently. Every platform is different. So what may take some operators, 15 months may take others 18 to 24. That's just, we're all trying to figure that out at the same time.
Jared?
Thank you. I wanted to, I guess what I'll say is I don't doubt that implementation of some of these restrictions is going to take some time. I think that seems reasonable to me. The one concern I have is that sports betting has just become legalized in the Commonwealth within the last year. And so a lot of operators are currently in the state of acquisition, of trying to acquire new users, trying to get people to use their platforms. And so in the interim, while say there may be a waiver granted, I think there's some concerns about what's being done with the information that's being used right now, and how that's being used and what's being done with it. So I think to that end, I would just encourage the commission to think about what sort of restrictions, rather than like waiving the entire compliance with the regulation. I would think it would make some sense to think about what Mina was mentioning earlier, in that there are some requirements that exist at the moment that may be implemented or implementable in the near future, and there may be some that may take longer. And I think it would be beneficial to spell out timelines for those particular requirements. But also I still have a concern that, a lot of the information that operators may be gathering is happening at the moment, say with the start of the new NFL season. So that's all I wanted to bring up.
And can you be more precise, Jared? I want to go to GLI and ask, these are complex businesses, this is technology, want to be realistic about what we'd expect. So I'm going to ask Joe and Mark, this is my question, commissioners, you raise yours. Is that kind of an approach, feasible? Could we pick and choose? But what would you want us to, what is it right now with respect to the acquisition issue that we can turn to in this reg to say to them, this is our concern, this is the AG's concern? Because we are really listening to the Attorney General's office, and a lot of input. So what would be the precise piece of the reg to tackle?
I guess what I would say is to the extent that the different use restrictions and consent requirements are really important to the commission, which it seems as though they very much are at the moment, those are not being used right now. And so there is data that is being acquired at the moment that may not be subject to the restrictions of this particular regulation. And so I wonder what happens to that data in the long run, right? Where does it go? Who uses it? Currently, business partners may be using that information and it may be out there, right? And so I don't have like a specific proposal at the moment, but I think it's worth thinking about, in the interim, before this thing becomes fully effective, if that's what is ultimately decided, what do we do with the information that is being collected about players at the moment? I don't know if that helps anymore or not, but
I think I'm hearing the consent framework that we've put in place is a real challenge. What I'm
yes.
So in the meantime, this information is being collected. Can the industry here in Massachusetts abide by usage and sharing details. And those precisely in layman's language, what does the AG's office not want to see us have them do with that information?
Yeah, I think the specific concerns that Commissioner Maynard expressed earlier, right? We don't want the information being sold to, say, a car manufacturer, right? Or being used in ways that the regulation currently prohibits, right? So like the regulation goes through a number of uses for advertising, say like periods of dormancy or advertising with social connections, things like that. They may take a shorter period of time to implement than say the consent mechanism, right? And so I think, you know, I don't have a specific list in front of me at the moment, but I'm happy to work and think about what could be implemented over time.
That was very helpful, Jared. Caitlin.
Thank you, Madam Chair. I just wanted to sort of add on to what Attorney Reinheimer said by way of timelines and the different pieces of the reg. So as he noted, you know, there are pieces that require implementation, for instance, switching to, you know, an opt-out process. And then there are also ways in which the algorithm is used. So you can't use your algorithms to advertise to someone based on the fact that they haven't played in a few days, right? So different things to think about. And so what the commission, just to say it while we're all in the same room again, what the commission asked for when it granted the waiver until November 17th was that each operator come back to it with a plan for implementation, including as detailed a timeline as possible for what can be put in place and when. So it may be that there are things you're already doing. In fact, you've told us there are already things you're doing. Great, we'll check them off the list. There are things you can do next month, the month after. And then maybe there are certain pieces, hopefully not too many, that'll take a bit longer. And so I just wanted to put back out there that the commission did ask for those materials in advance of the 11/17 end of the waiver. And then that will help the commission, based on this conversation and future conversations, to sort of figure out the next steps for, you know, presumably additional waivers will be needed based on this conversation. So I just wanted to put that back out there while we're all together.
Thank you, Corey.
Just wanted to make one suggestion, which is that the car manufacturer example really makes me think of the California Consumer Protection Act, because it has very clear language about the sale of information. Sale is defined extremely broadly, any sort of commercial arrangement. Many of the operators may already be complying with CCPA. There are also vendors out there in the world who will help you comply with CCPA because it is such a broad regulation affecting much of the online world. So if the language here were to mirror CCPA, it would address some of these concerns and I think allow for a much faster compliance timeline. I'll stop there.
Commissioners, responses to that or to Caitlin or to Jared?
I just had one other question, which is framing what we've talked about a slightly different way, which is, would the opting in make you non-compliant in any other U.S. jurisdiction? I'm taking it from the conversation that's not the case. It's more the implementation itself and the issues with that, but I wanted to ask that question specifically.
That's not, Corey, you were
I defer to my privacy expert colleagues on the call. I don't think it would make us non-compliant in other jurisdictions. I think it's an implementation challenge, but I'll let others speak.
That's what I thought.
Anybody else? Okay. I'll turn to the Attorney General's office. When I hear Corey say, you know, mirroring the California Privacy Act, what do you think about that, Jared?
I think there are some valuable parts of the California law that are already implemented here. I think, you know, it seems like the big stumbling block right now is the consent mechanism, and that does differ from California's current implementation scheme. I think that, you know, this presents a real opportunity for the commission to take a leading role in regulating how this information is used. And I think that's very important. And I don't think, although yes, this might be unique to the United States, you know, this type of model has been implemented elsewhere, and so I think that it may be a challenge to implement, but I think it's worth doing.
Yeah, and California doesn't have online sports betting yet. So the statute that you're talking about is not quite, you know, laser focused on this industry, which might also speak to part of the reason we might be in the forefront on this.
Yes, thank you, Commissioner O'Brien. I think that's another valid point worth making, is that this is a different industry. It's not, you know, the California law is a very general, broad-based privacy law that affects all industries that operate in California. And I think that, you know, mobile sports betting is different. The way that data can be used, I think, is of a big concern to our office, particularly because there are real concerns about the addictive use of the platforms and the public health considerations of that. And so I would, I think it's appropriate here to implement this type of consent mechanism in particular.
Madam Chair. I was also thinking about Jared's point about, you know, where does this data go while these timelines are being implemented and so forth. You know, the more I think about it, you know, maybe the data and the raw data should just be given to the IEB and to Research and Responsible Gaming until, you know, conditioned on any waiver that we would give for people implementing this, and we can just get all the raw data. I mean, I'm just trying to think about a way that, you know, we make sure the consumers are protected while we're waiting for something like this to be put up. So.
May I address?
Yes, that'd be helpful. Thank you.
I'm, you know, we do have all public-facing privacy policies that our consumers do or do at least acknowledge at the time of sign-on, and when they're adjusted, they're at least at BetMGM, they're presented with the changed privacy policy. So, you know, I understand that if Massachusetts wants to go further than opting into a broad privacy policy, which I, you know, is a fine approach to take, but we aren't, it isn't all cloak and dagger behind the scenes selling of data. We are all making presentations every day about how we use the data so that our consumers that are interested in privacy can see that, can opt out of marketing or of other usages in certain ways. So, you know, there may be retroactive anonymization or things like that as we move forward, or we ask for specific consent. I know that we've got the ability to put a banner up and say, you agree to all of these things. We could probably do that in a way later when we've all aligned on what those consents are. But, you know, we are trying to be open and honest with our patrons about how we use the data. I know many jurisdictions require review of our privacy policies before they're posted. I'm not sure specifically about Massachusetts, but we are, I think, as an organization or as a group, we do try to be open and honest with what we're doing with our data now, with the data we collect from customers. I spend a lot of time with our privacy policy. I don't know how many people read them, but they are very thoughtfully done.
Other questions for David? Yes.
I just want to add, I think some of this discussion is what I was talking about up top, which is to the extent that a lot of these concerns are about uses of data that the commission, you know, finds to threaten responsible gaming practices. You know, that's a separate issue than a consent management regime. And so I think there's an opportunity to take some of those things separately and say, you know, let's look at really targeting some of these things towards those uses. And then the consent management regime is kind of, that's the long-term the secondary thing we need to deal with. But that's some of the things, I think you mentioned some, egregious examples. You don't want people to use, PII to market to people who are coming off an exclusion list or who have registered for RG services. Well, sure, absolutely. But that's not, that doesn't necessarily implicate consent management. That's just an RG practice where you say, hey, you shouldn't use this information to market to those people. And something that is, just much more technically feasible than kind of flipping the consent management regime entirely, if that makes sense. So I think what we're saying is, we want to work with you to accomplish what the goals are, just with an understanding that some of these things really are super highly technically challenging for us, and some are not. And so, figuring out what those things are and what the immediate priorities of the commission are, I think, are helpful.
We do have one more slide about some of the clarifications that we're requesting. I think we actually have two more slides. I'm not sure that both are sort of necessary time.
Go right ahead, please.
But I think it would be worth it to at least show.
I think we've discussed some of these today. I think some of them have not yet been answered by the commission, and that there's an opportunity to continue the conversation. But broadly, the greater the ambiguity, the longer the compliance timeline for any of these things. And so, the more we can answer these, the more it will help us in scoping. The first one here is about, we already talked a little bit about sharing with third-party vendors and how even if there's an opt-in, that's not necessarily clear under 257.03. Secondly is a clarification where the regulations allow use of confidential information or personally identifiable information to investigate, respond, and defend against filed legal claims, but not necessarily for threatened or anticipated legal action, which would leave us unable to, for example, preemptively demonstrate to a plaintiff that their claim is without merit. For example, they say they never agreed to terms and conditions, and we could show them that they did that. Similarly to, defend to unfiled actions by government agencies. M&A transactions, for example, can we transfer PII if there's a merger or an acquisition? And that there's no exception here for that. We already talked a little bit about encrypting publicly available PII like usernames. The next question about using social platform data is primarily based around RG, and I think we've all agreed that we need some clarification that RG purposes are used. So, for example, operators may currently use some kind of social platform data for RG purposes to determine if someone has an issue. It's not clear if that would be allowed by the current language. The third-party forensic examination here is a data breach question. The commission is allowed under a breach to request a third-party forensic examination if there's a security incident. We need to understand if those would be public or not, because it'd be a pretty significant cybersecurity risk, because those would contain pretty sensitive corporate security information. And so looking for guardrails on subsections. The three questions about necessary sharing and reasonably expected to make a wagering platform more addictive are the kind of things we're talking about, that these necessary and sharing are legal terms of art, and they're not defined very clearly here. It's also not clear what is reasonably expected to make a wagering platform more addictive. I mean, that could be, it depends on what reasonably means, and I hate to parse it, but I'm a lawyer. As Alexis has said a couple times, this is kind of these are the questions that we need to understand. And then finally, one of the things that is not present here, but is present in other privacy laws, is anonymization or aggregation of records in lieu of full deletion. If someone requests that we delete their data, if we basically de-identify it so we can still use it for analytics purposes or generic RG or things like that, is then acceptable. So these these are the kinds of questions I think every operator will have a bunch of these that would be helpful for us in scoping what compliance requires, and then also raise some issues that we may want to consider revisiting because we want to understand what the commission's intent are. Like, I'm confident these aren't the only questions, but they're a start. That's a lot of questions.
And I know you have another slide, but I've got Mina with a hand raised, and so maybe it makes sense to take the slide down so we can see each other, please.
Sorry, Madam Chair, I was actually going to offer, since I know based on Commissioner Maynard's questions and Caitlin's comment that there may be a desire to sort of, and the timing, there may be a desire to see some additional implementation. I'm happy to try to answer some of those questions based on the language of the reg if you want, but I also defer that to a later meeting if you prefer. So that's entirely up to you.
You mean in terms of offering language that would address some of the issues raised?
Well, to be completely candid, offering where the language in the existing reg answers the question and to suggest that maybe if we need to tweak, we can, but some of these, I know we answered some of them. I'll take an example of one. The WinBet, again, gets the credit for this. They had suggested language that we used, I believe, verbatim, to allow responses to legal claims. And we didn't use lawsuits, we didn't use legal action, we used claims for exactly this purpose. Of course, it is necessary to run a business. One needs to be able to respond to legal claims. Again, I just want to be, I think we've all talked a lot and we've gotten really helpful feedback on specifics of implementation. So we just want, to the extent that we can get folks off to the races on what they need to tell their IT folks, then if it's helpful to answer questions, but I don't want to overstep. So if that's for a later time, we can save that.
Let's go to the second slide, on the next slide, and then Mina, you can come back with your clarifying list. Okay, thanks. And I think I'm going to lose Dr. Wall. So if we have questions for Dr. Wall, if we haven't already lost him. Okay. Why don't we go to the next slide, Alexis? Whoever had, or David, thank you.
That's really all we had. We had another slide about various implementation timelines, but we kind of covered that.
Okay. Commissioners, do you want to hear Mina's list? Because my instinct is to have Mina go over his feedback to make sure we're all listening and hearing the same thing. Because, some of the things I'm hearing, Mina, you say it's clear, it's in the reg, but maybe it's just not as clear because we're not implementing it. I'm not the
Absolutely.
One, writing the code and doing
Right.
the marketing and all. Okay, so Mina, why don't you go over some of your thoughts? The one you just raised, is there a response to that one?
Yeah, if I could ask for the slide back, there are a bunch of things on there.
Okay,
It may just
we'll go
be
through the
easier.
slide. Thank you.
Let me get that back up here.
Thanks, David, and then we'll just have to shout out, okay?
Yeah, sorry. and to be clear, this is not intended to be an oral argument. The regs already say this, they don't. What I'm suggesting is if the commission already believes or agrees, with the interpretation I'm suggesting of what was intended, then the legal team has a pathway to go back and suggest additional clarification to make sure we're on the same page. If there's a policy question that needs to be addressed, that's a different process, right? And so that's the kind of guidance I was hoping to get, Madam Chair.
I don't know how the other commissioners feel, Mina, but for me, policy implications include business, implementation challenges.
Of course. Of course.
The risk assessment. Okay.
Exactly. Of course. Yeah. Of course. That's what I mean by policy. Yeah. Number one, I think we talked about a lot, so I don't think there's much more to say. So, shared with third-party vendors, I think there's this question of what kind of third-party vendors, is it sort of implied from the consent given or not? So I'll leave that one alone. On the second one, that's the one I was responding to, reasonably anticipated litigation. I can see, a lawyer reading to respond to and defend against legal claims, worrying how soon can I use that information, or do I have to wait until someone has sent me a formal demand or a lawsuit? So that perhaps warrants some clarification, but the intent was certainly to allow folks to be able to, because that's the nature of the comment that came to us from WinBet initially, was that, was this precise concern. So if we didn't address it fully, I think that's one that may be worth a tweak. So I'm just looking for any objections to that. The Commission's intention on non-transferable and M&A transactions, I'm not sure I can answer that one today. Again, if it's sort of in the normal course of business, that may be a little different, but that's, I think, gets at the heart. I don't want to speak for him, but what Jared was speaking about, that, if the data is acquired now, what's done with it, if it's protected the same way, maybe there's a way to specifically carve that out. I guess I was looking for a little clarification on encryption of publicly available PII. When we were referring to encryption, I'm using as an example, most law firms in the world don't do their work except behind encrypted, cloud systems, or that's where almost all data is in. I think Gmail is encrypted. So when we're talking about encryption in the reg, what I was a little bit confused about is, and maybe this is not to put anyone on the spot today, but one clarification that'd be helpful, I think, to our team would be, what kinds of things aren't encrypted today or be impossible to encrypt, as opposed to when they're used by the operators are behind some encrypted system. It doesn't mean that they can never be seen, but they would require some specialized access. I couldn't go into the operator system and just look at them myself. The social platform data, I think we talked about. The reports available to third parties, as I think has been covered many times, for better or for worse, the legislature did not give the Commission full protection of all data under sports wagering. However, most times an investigation is subject to the investigative exemption under the Public Records Act. So it'd be a case-by-case basis, but I think there'd be ways to handle that before a record came in the first place. And then I think the last the second to last two, the necessary and sharing, we've talked about. Reasonably expected to make the platform more addictive. I think the reasonably there was intended to be a bit thrown, to give some work to the operators to try to make sure that they understood what they were doing with the data. I don't know that the Commission could possibly figure that out in all instances, but it does require a bit of an intent element. And if I'm not mistaken, and I would have to go back, so the reasonably may have been added at the request of somebody there. So it was one of the few places we used the word reasonably, because we've been asked to use it many times. The last question I think we'd have to think about. So I'm not sure, I guess one question to the operators might be, what would that do in terms of changing implementation timelines and implementation protocols if anonymization and aggregation in lieu of full deletion was acceptable? Because that doesn't sound like a front end thing. It's more of a back end thing. That's what I'm trying to understand.
I could answer that. I think that anonymization, which we would believe is the same privacy protection, because now data that is available in a system is associated with a number and not a person. So all of the goals of privacy are fulfilled when you fully anonymize the records, but still allow for additional uses, subject to whatever consents were obtained, additional uses for the data in an aggregate way, or for RG purposes, as David mentioned. So it would be easier to do. In fact, we anonymize now for deletion in other jurisdictions, and so I do think it's an easier lift for sure if you are usually the identifiable information is in a limited area. And then there's, perhaps in other areas, there's just a number, an account number that no one would know that that's that person unless they had access to the personal identifiable information. So it does certainly make things easier to implement. If we had to do a full deletion, then I think there's now a larger scoping exercise just to figure out exactly where all of this data may exist and how difficult it would be to actually remove it, which sometimes turns out to be a lot more difficult technically than it would seem.
Jared, if you want to respond to that, that might be helpful.
If the information is collected under a consent mechanism that's already in place, say like this system is already implemented, I'm not sure that the consumer's intent would be for the data to be anonymized instead. And so my concern there is just doing what the person actually intended to do. There are some concerns surrounding anonymization in the sense that often that information can be used to re-identify someone when aggregated with other pieces of information. So for example, there's a really well-known study that, I'm going to get the types of data wrong, but I think it's like gender, zip code, and age or something you can use to identify someone pretty well, like 90-ish% accuracy. And don't take my numbers as what the words are, but it's somewhere around there. So I think, if that is the direction that this goes, there may need to be some guardrails around what types of anonymization and aggregation are done. For instance, in the CCPA, there is a requirement that the information not be reasonably connectable back to the individual. And so I think we just need to think about implementing something like that as well to make sure that there is a real guardrail there, because simply deleting someone's name may not be sufficient to not be able to identify them in the future. And I see Chris nodding, so
I absolutely understand the concern, and in our process, we don't stop with name. It's date of birth, it's email, it's address, it's gender. It's all of the things that as we went through and looked at it, what is there enough still here that someone could figure out who this person was? And so the CCPA standard, I think, would certainly be appropriate, and something that I think the operators could, I guess I'll only speak on behalf of Cedars, but the operators could implement quicker than a full deletion process.
Right, that issue around triangulation, Jared, we deal with it in Massachusetts. State agencies share data among each other with under strict agreements in order to really deliver evidence-based public policy. So I think there's so many ways to make sure that that anonymization doesn't result in any kind of re-identification. So I understand Commissioner O'Brien's point. Yes, California doesn't have sports wagering, but in terms of that's not unique to sports wagering. I guess I'm trying to see where we can do proper tweaks without compromising what is really essential to the issues around sports wagering.
I think that's a really helpful insight, and I appreciate that. I think that given that it applies, CCPA applies to every industry. There are certainly plenty of industries where you wouldn't want to do that. And, Mr. Renheimer's correct. The, CCPA has really detailed guidelines on how to do that, and relinking, and, it can't be available when you anonymize or aggregate data. So that's the kind of tweak I think we're talking about in a lot of these areas where, we think we understand what the intent is, and maybe there's a way to accomplish the same goal that's technically a little more feasible. So I appreciate those comments.
Commissioners, if we can keep this slide up where we can go back to a conversation, and I know we might be winding up, but I want to make sure we take advantage of this this group of people. And I see Sarah. If we could have, Sarah is weighing in.
Hi. I just wanted to weigh in on one of the items on that last slide regarding the forensic examiner reports and what it is that the commission would be seeking. I do understand that there's some statutory rules around what can and cannot remain confidential. And this is important to us just because what this commission is asking for seems to go beyond what is typically considered a public report after a breach. Namely, asking for plans for remediation, mitigation, future prevention, and again, that examiner's report. We had similar rules coming before the SEC recently, and they also took up this issue and decided to narrow what could be collected and disclosed publicly, just understanding that some of that could actually put our security at greater risk by being made public, as opposed to giving real value to the public to see that. So I heard Mina say that there are some ways that maybe before a report is submitted, we could protect that under some confidentiality, but I guess I would like to better understand that, given that that's not clear in the face of the regulation.
Mina, can you direct us to the?
Sure. So this is 257.063. So this was phrased that it was upon request by the commission. And Sarah, to your point, I think the reason this was upon request as opposed to an automatic was to allow for a give and take for exactly that kind of conversation. We want to be careful about where this report ends up or who has a need to see it. The commission has its own, from what I understand, and Todd or Caitlin, I think you may be better positioned to explain this, but its own internal security protocols. So this would likely only be seen by folks at the IAB or others who need to understand it to help the operator protect patrons going forward and operations going forward. With respect to what I'm talking about on the public record side, a common concern with the Sports Wagering Act has been that it doesn't have some of the same protections for public information that the Gaming Act did. However, all the exemptions under the public records apply, and a public entity getting a security sensitive, and I'm using that in the small s words, not in the defined term words, report would normally be protected under the Public Records Act from further disclosure. But Caitlin or Todd, I don't know if you want to add anything to what I just said.
Yeah, I think that's right. And, it is a challenge we face under the Sports Wagering Act as opposed to the Expanded Gaming Act. And we deal with it all the time for all kinds of things that are required to be submitted. But I think Mina's right that it's not mandatory in every instance. When there's an issue, the commission can decide and then have the back and forth about what can be given and how, so that obviously we wouldn't want to have any security concerns with the information.
Appreciate that. Thank you.
Do other operators want to weigh in? Commissioners? Okay. Must be lunchtime.
Madam Chair, sorry to say one more thing, but this is just as a matter of fairness. I did look back. Reasonably expected was our language, not the operator. So I just apologize because we had seen that comment before, but didn't want to be misquoted on that.
Thank you, Mina, for that. I think for next steps, first off, I think the first next step is to thank everybody for your time and your willingness to be candid and to help us understand. Commissioners, I'm going to let you express your gratitude, and then we'll go, I think, in terms of general next steps. We have an agenda setting meeting next week, commissioners, and I think we can think about how we want to digest this information. I know we have a November 17th deadline, and there's some process that Caitlin outlined that we are hoping that the operators can give us that's more nuanced. But I also hear that they're looking for more guidance from us, and to the extent that we can be helpful that way. On 1 of 5, I would be inclined to be as helpful as we can, but we need to circle back as to next steps. Commissioners, feedback on that point, and then we can express our gratitude. Commissioner Maynard, what are you thinking on process for next steps?
Mr. O'Brien, are you?
Oh, I'm sorry, Commissioner O'Brien.
No, I think what Caitlin talked about, and I can't remember who else talked about it too, which is this is a work in progress. So I thank everyone for their time and their comments. I think we did put a lot of thought into this when we looked at it the first time and when we voted. And I do think we have the mechanisms in terms of we've given some information for clarification. We've asked for other information from the operators in terms of what's implemented now, what's possible, timelines, what's still TBD because maybe they need more information from us. To me, that next document will then guide where we go prior to the 17th of November, because it may be a more tailored waiver, really speaking to what it is that needs longer times to figure out what timelines are going to be. But this has been very helpful for me as one commissioner.
Commissioner O'Brien, what about the tweaks that Mina has mentioned and that we've addressed today that are possibilities? What would be the process for that? I know we've already have a reg, but the beauty about regulations is we can always revisit them. What about those tweaks?
So I think what they need to do is be memorialized so we're all clear on exactly what the tweaks are, to make sure that that's not requiring further clarification, that the operators don't need something even more, pointed than what's already been discussed. And then I think we can deal with it. It may be that this reg is going to have to come back up in front of us a series of times for minor tweaks, but ideally, if we get this information memorialized, we get the information we had asked for in terms of, you now have some answers, give us, what is done, what is doable on a certain timeline, and what is still unanswerable potentially because you're looking for clarification, then I think we can get to the next stage in terms of any cleanups that might be easy to do and any waivers that might be necessary.
So legal, commissioners, if you're in agreement with that, we would need some guidance from legal as to the process for properly doing that in the regulatory promulgation process. Commissioner Hill.
Yeah, I would agree with what Commissioner O'Brien just stated. And I want to thank everybody who came today. It was very, very informative. Food for thought, for sure. And I think the processes have been set up where we can be helpful to you and you can be helpful to us.
Excellent. Commissioner Skinner, what are you thinking?
There's not much for me to add on process, although it's almost a question for me is, what comes first, the chicken or the egg? We've had a lot of give and take here, and I understand the operators need to have the commission provide some clarification. Hopefully you did get some good clarification on some of the points today. I am looking forward to the material that we have asked back on August 8th for you to submit for us to further consider in terms of any additional waivers or an extension of the current waiver. I want to add my voice to the chorus of thanks to each of you for participating in this roundtable today. And in particular, our partner from the Attorney General's office, very, very informative in terms of your contribution to this discussion today. To our sports waging operators, I think that you've expressed a real sincerity in working in your desire to work with the commission and the team here to get this right. And so with the additional time that we have between now and November 17th, I'm hoping we can make some real headway on a regulation that is that does exactly what the commission intends for it to do, but then also respects your technical challenges and some of the other concerns that you raised before us today. So just, I'll stop there. But just a thank you once again.
Thank you, Commissioner Skinner. Commissioner Mayor, yeah, thank you.
Thank you, Madam Chair. I echo my fellow commissioners. I appreciate the operators for coming on in the candid conversation. I think that, you know, I tried to ask questions that were outlier questions because I'm trying to figure out, you know, I'm trying to parse everything out, right? Versus what's impossible, what's possible, and what's inconvenient. And you know, to that aim, it's always in the back of my head that I'm speaking for myself, as one commissioner, put intense pressure on the MGC team to implement 23N and get it going. And I will put as much pressure on making sure that the citizens of the Commonwealth's privacy is protected. And that's just where I come from on this. I think Jared and Mina and GLI and our RG partners for putting more light into what's going on and where they're coming from. And I just want to get this right. I want to make sure that a citizen in Massachusetts knows how their data is being used, that they're treated fairly, that and we may be on the cusp, we may be ahead of the game nationally. That's okay with me. I'm fine with that. And so, you know, but I want to get it right and I want to be fair. I want to be fair to everyone. So thank you.
Excellent. To all of you, thank you for joining today. I think I echo all of my fellow commissioners' sentiments. This is a complicated topic. We appreciate that you asked for this opportunity, and I'm really pleased that we were able to extend it. I appreciate that you're comfortable asking, and so to that degree, you know, we're cooperating. We won't always agree with every element, but you know, I think we are operating always with open minds. And I do echo my fellow commissioners that we may not have been terribly vocal during that meeting, but we worked on it. And so with that, you've given us a lot to think about. We've got some process questions to go forward. I again thank the Attorney General's office. Been a very important, is our Commissioner Skinner's term partner in this effort, because it is your area of expertise. Quite simply, across the nation, the Attorney General's offices are leaning in on these conversations, and I really very much respect Attorney General Campbell's efforts here, and she's very well represented by Attorney Reiner. So thank you for that. And then to our GLI partners, thank you. We may be meeting you again as we get the feedback on the timelines and the implementation. I've learned a lot today, and always respect the fact that I am not in the operator's shoes. I don't understand all the complexities, although we, you know, I think you conveyed them to us today with a degree of precision that will be really helpful for us going forward. So thank you. Anything else to, and of course to A and K and our legal team, thank you. I always feel like it just means more work, but as everybody said, you know, we're all working to get this right. So thank you. Okay. Commissioners, I just want to turn to all the guests. Is there anything that you want to leave, you know, to say that you're going to just regret that you didn't say? It's okay to say something.
Right. I just want to thank you for your time, and you know, we really look forward to continuing to work with you moving forward. I want to give a special shout out to Director Band and the staff who have been, you know, throughout this whole process, extremely helpful and available to us. So thank you for that.
Yeah, you know, and Bruce, thank you. I know that you've been reaching out, and your team. We're all working hard to stand up this industry in a way that will work to make it sustained. strong industry here in Massachusetts, and we're pretty lucky to be able to have these kinds of conversations with the quality of operators that we now call licensees. So thank you, and thank you, Bruce, and thanks, David, for that. That means a lot. All right, then with that, I need a motion to adjourn.
Move to adjourn.
Second.
Thank you. Any edits, questions? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes.